former President Jacob Zuma's bid to appeal against a ruling that could see him stand trial for corruption has been dismissed by the Supreme Court of Appeal. The court issued its decision without even hearing arguments from Zuma's lawyers. The Pietermaritzburg High Court dismissed Zuma's application for a permanent stay of the 15-year-old prosecution. He had approached the Supreme Court of Appeal to appeal that decision. Now, for more on this, I am joined in studio by Karyn Maughan, Newzroom Africa's editorial contributor. Karyn, good afternoon. Thank you for joining us. Let's look at the background of the case and perhaps the significance that this ruling has for Zuma and his legal team.
Well, basically what has happened is the state says it's ready to prosecute Jacob Zuma in terms of a 15-year-old corruption case that deals with his relationship with his former financial advisor, Schabir Shaik, who was convicted of corrupting him and facilitating a bribe agreement between him and a French arms company, Thales, in exchange for Zuma's political protection from any kind of arms deal investigation. And the state says it's ready to persist with that prosecution as early as April this year. So what Jacob Zuma did last year was he argued that his prosecution should be permanently stayed, he said, because of undue delay, because a wide range of alleged political interference in his prosecution, which he said tainted it to the point where it couldn't continue, violated his rights to a fair trial, etc. The High Court in Pietermaritzburg, 3 of those judges saying, you can raise all of these issues when you go on trial, but you must go on trial. The seriousness of the charges you face, given that you also face a 25-year jail sentence for racketeering linked to those charges, means that it wouldn't be in the interest of justice for you not to be potentially held accountable in a trial situation. He then sought leave. They dismissed his application for leave to appeal. He then petitioned the Supreme Court of Appeal, who have just issued 2 orders in terms of him and Thales, basically saying you have no reasonable prospect of success, and there's no issue that we feel, there's no issue that we feel would justify this appeal being heard and us even hearing argument on that. So there's been no argument. It's just on the papers that he's filed and they're not even hearing it. So it's a pretty resounding signal from the SCA that they don't think this particular case has any hope in hell of succeeding.
So based on that, what are some of the avenues that he can explore should he want to then continue?
Well, he can make a direct appeal to the lead judge in the Supreme Court of Appeal, the judge president, and say, listen, I think this was the wrong decision, and I think you should reconsider, which a lot of people do. If that fails, he then can try and bring a leave to appeal application to the Constitutional Court. But given that the SCA has pronounced in the way that it has, he would have to raise a pretty novel point for... and I don't think on the papers as they stand necessarily now that at this point that he's got that kind of argument. We must also remember that Thales has brought an application in the Constitutional Court around a whole range of aspects regarding Sean Abrams' decision to reinstate the prosecution against it, and that obviously has implications for Jacob Zuma. And the Constitutional Court hasn't made a decision around that, but we are expecting a decision quite soon on that issue.
The state insists that he's doing this as delay tactics of sorts. Some saying he's just exercising his right as a citizen, testing the judicial system at large. What is emerging from this case in particular?
Well, the National Prosecuting Authority, it's an oft-quoted reference to his so-called Stlingrad strategy, which was, of course, a term that was coined by his own lawyer, Kemp J. Kemp, I think in the sort of 2008, 2000, around about then, when he said, we'll fight them in every room, in every street, in every house. And Jacob Zuma, when he was facing the corruption case, brought multiple applications challenging the search and seizure warrants, challenging the mutual legal assistance request that was sent to Mauritius for certain evidence, challenging the decision by the state not to pursue the case against him, their attempt to postpone the case against him. So there have been a wide range of challenges, and his argument has always been, but I have a constitutional right. I can use my my ability to raise these kind of issues, challenge the case in the way that I have. The state's always said, well, why didn't you challenge it in the trial? If you have a problem with the search and seizure, if you have a problem with the mutual, bring all of these issues up in the trial. And the courts have actually pretty much agreed with the state's stance. So the state is saying, if you have these issues with, your prosecution, political interference, etc., 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 your memory, not being able to remember. Raise those things in the trial. Let the trial court decide, and if the trial court rejects your arguments, then you can try and bring an appeal. But Jacob Zuma's case is that why must he be dragged through a process that he believes is illegitimate and unfair? And he says that he doesn't believe he will ever get a fair trial at the hands of the NPA, and this is why he's pursuing the avenues that he has. But at this point, it seems very, very much that he's getting into a corner, and I don't know that he's going to get out of it. I think that there's a very strong possibility that we may see the former president of this country, first time in democratic history in South Africa, going on trial for corruption within the next few months.
I actually wanted to touch on what this case does, in the public perception. What does it reflect, just in terms of party politics as well? Some supporting him, some not, the factions as well. What do you make of that that's emerging? I mean, I know that former President Jacob Zuma also said that it's part of a politically charged campaign against him. Walk us through what's emerging on that front.
I think the difficulty with this case, and it was an argument that was made by him but refuted by the NPA, was that at the time that Schabir Shaik was prosecuted, it was the view of the prosecutors, Billy Downer and others, that Zuma should be charged with him. And he wasn't. Now, Bulelani Ngcuka has said that it was for a wide range of issues, including the potential for public violence, if the public felt that he was being unfairly prosecuted, etc., etc. But the difficulty with that is that the Shaik judgment came out in 2005. We're now looking 15 years down the line. Zuma was charged in 2005. 15 years down the line about matters that occurred in the late 1990s. So we're trying to claw back a history based on a series of decisions, which I think, the NPA, the courts have accepted the NPA's explanation, but I think it is unfortunate that that case did not happen then. And I think it has always been his strongest point that he should have been tried when Shaik was tried.
Karyn, there's so much more to unpack, the legal fees, who's paying for all of this, but we've got to leave it there. Karyn Maughan, our editorial contributor, obviously just chatting to us about the Supreme Court of Appeal that dismissed former President Jacob Zuma's bid to appeal the ruling in that corruption case.